Good afternoon. Hi. I'm back. Um, Today is Thursday, and you know what that means. It's Thick of It Thursday. Every Thursday at 4 p.m. Eastern Standard Time, I go live. I go live and I discuss relevant divorce and no custody matters, issues, topics that my audience, viewers, listeners either ask me about, mention in some way, or we just engage in a discussion about. Sometimes I'm just motivated by a topic that pops into my mind. So anyway, a couple of weeks ago, I started promoting my one of my workshops that I'm really amped about, which is going to be a pro se trial prep workshop. It's going to be a three-part series, and I think I initially went over a brief um, outline of the topics that I'm going to cover. So today I wanted to delve in one of the topics, and I'm just going to delve into this topic because it's very relevant. It's very widely discussed, and it can be controversial actually. So I chose that topic because of that, and because one of the cases that I'm currently working on has this particular issue involved. So today I'm going to talk about the use of text messages, recordings, and such in family court matters. And I always make a distinction about family court because family court is a little different than just civil or criminal court or any other court. It's different because it's not, it's usually not a black and white venue. It's usually involved involves several areas of law and mental health and social service and life issues. And so it's usually, um, it's typically seen by most professionals in the legal arena as a court that is very nuanced because it has to deal with so much. Um, so I always make that distinction because a lot of things that apply in a lot of other courts do not apply in family court and vice versa. Now, jurists would argue that, depending on which side of the defense they stand on, some of them think that, family court is a court and therefore it should not have any lax with regard to its laws, rules, regulations, procedures, and et cetera. And then there's another school of thought where jurists believe that because of what I just said about it being a little different and nuanced, that some rules should be bent a little bit or, broken or overextended, whatever the semantics you want to use. So either way, I'm a realist. I'm very practical. And I see things exactly for where they are for me, from my perspective, from where I stand or where I sit. So I'm not going to debate about, what's what. My thing is, I do what the court allows me to do. And every court is different, every jurisdiction is different. So, well, when I practiced anyway, but as a strategist, consultant, and coach, that's one of the things I do. I like to get an idea of the jurisdiction my clients are in and get a feel for how they operate. Never mind how the laws in that particular state apply or are applicable or enacted or active or whatever. I use what that particular jurisdiction is prone to use in similar instances, and that's where the strategy for me comes in at. So anyway, now that I've said all that, I want to start with text messages. So 2021, everybody texts, right? Um, I'm pausing because I'm trying to think of, yeah, one of my friend's mom is, I think, 80 and she texts. And I'm bringing that up because I want to drive home the point that almost everyone uses text messaging as a means to communicate right now. And that's different than 10 years ago. 10 years ago, not everybody texts. A lot of people text, but not everybody. That's my method that I choose to use. I love texting. I just don't have you know, the attention span to have phone conversations too much anymore. I prefer text messaging. Um, but so how are text messages used in custody and or divorce proceedings? They are used. It comes up all the time. It is a topic that is, like I said, widely discussed amongst jurists, amongst litigant parties, amongst other professionals that are somehow involved in the family law field. It comes up. It comes up for several reasons. It comes up because um, a lot of times it's used as evidence. A lot of times, the question of whether or not it is appropriate for others to view comes up. Um, what of text messages is appropriate or valid or material comes up. So, depending on which side of the table you stand on, you may take any one of those positions as far as text messaging is concerned. But the reality is that text messaging is something that is used, it is addressed, it is considered, it is factored in to uh, divorce and custody proceedings, especially when it's 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 aimed to be used as evidence of unfitness, of abuse, of whatever it is. So, how do you use text messages in your divorce or custody case? Well, that depends. That depends on number one, where you are. Um, that depends on the issues in your case. That depends on the background of your case, um, etc. There's a whole list of things. But what I always tell people is that use save your text messages. Yeah, I do that as a strategist. I like to see everything. Because I'm a strategist. So some things you may think, or someone else may think, even your lawyer may think, is not relevant, is a waste, is unnecessary, et cetera, et cetera. I may see value in. I may see an opportunity to use it in some shape, form, or fashion. So I always encourage people to keep the text messages. Um, and then it depends on, how I'm working with my client. I will go through them with my client to either organize them, um, use them as leverage, categorize them, prioritize them, blah, blah, blah. So, and it works. It's very tedious, but it's very, very, very effective um, for my client. So, what do you, how, okay, so using text messages as evidence in court. First of all, text messages are something that needs to be um, authenticated. And what that means is if you're going to use them as evidence, you need to prove to the court that whomever you're alleging is the sender of the text messages is actually that person. So what happens is that most courts will only accept text messages, will only consider text messages as evidence if they've met some basic requirements. And one is that it's relevant. If you're trying to use it to prove an issue or a topic or a fact in the case, and that it's authenticated. So text messages, you can't just go into court and say, Judge, look, I have my phone. I want to show you all the text messages that I received from my ex or my soon to be ex. Judge is probably not going to do that. Now, the law guardian might do that, or the guardian ad litem might be prone to want to see that. But again, that's entirely up to them and how they do that, because that's not being admitted as evidence. That's just to show the the guardian ad litem or the law guardian, um, the issues that are current, the issues that are present in your case. And it helps that law guardian or GAL to take a position either way. But it's not being the law guardian, the guardian ad litem is not going to use that to admit it as evidence. And if they do, there's a whole series of hurdles that they must jump over to get those admitted, because if they're not the recipient of the text messages or the sender of the text messages, then they're a third party, and it could be hearsay if they try to admit it themselves. So that's a whole other topic, though. Um, so what what attorneys usually recommend, and me too, whomever is helping you or whomever you're getting information from, is that you download the messages. You either use an app on Android or iPhone, and you download the messages to one of the apps that will convert the text messages to either a Word document or a PDF document. Or you screenshot it, because when you screenshot the text messages, it has the names and the phone numbers, the date, the time, sometimes the location. So that helps to authenticate, who the text message was sent from or who sent it to, and which will help authenticate the actual parties that the text message exchange occurred between. And that's important to the court. That's very important to the court, because just like technology has advanced with regards to text messaging, it's advanced with regards to what do you call it? Like photoshopping. You could edit, and there's another word for it. I'm drawing a blank. Where you can edit things to make it look like David sent you this text message, where in actuality, David never sent you the text message. You just something random you got, and you just played with it and made it look like it was really a message sent from David. So that's the purpose of authenticating it. And that's the reason for downloading it to an app that organizes it for you. And again, that is something that most lawyers, whomever you're working with, they will tell you if they're familiar with getting text messages into evidence, being admitted into evidence, or even getting the judge to look at it. And I'm saying that because sometimes judges just look at the text messages not as evidence. When there's just like say you file a motion, an emergency petition, or an order to show cause for a change in custody or a change in visitation, and you want to show the judge something to substantiate your motion, your application. Sometimes just, printing out the text messages will suffice for that purpose. So it's evidence, but it's not really evidence, because it's not part of a trial or hearing where it's sworn in and all that stuff. So there's a difference. And I may say things to make that distinction clear. So another way you can do that is to get the text messages directly from your phone provider, AT&T, T-Mobile, Verizon, whatever else is out there. I don't think Sprint exists anymore, but you can get the text message diary or log or whatever. You can get it directly from them. If it's your phone, then you can reach out to them. Some of you could just go onto the internet and go into your account and print it out that way. I don't know. I don't think I've ever tried to do that myself, but that is a way to also get them authenticated, because when that's done, it actually whomever your carrier is, it has that information on the top. I'm going to try that out of curiosity, just to see what my carrier would do, how it would actually download, and how it would look when I print it out. So you can use those. So if you could get those admitted into evidence that way, then the judge can actually consider the text messages, like I said, in a domestic violence case, in a custody case where the parents are fighting over custody, or abuse neglect cases. text messages are certainly relevant in those instances. Uh, but again, that's going to be up to the judge. That's going to be entirely up to the judge whether or not what's in the text messages will have some impact on the determining factors to decide custody or whatever else, whatever the issue is. But again, the easy answer is text messages. Yes. Keep them, download them, what do you call that? Convert them using an app. Oh, I wanted to mention something briefly because this has come up too recently. Our Family Wizard, and then I think the other one is Talking Parents, and then there's another one. There's a third one someone mentioned a couple of days ago. Those are communication apps for co-parenting. A lot of parents use those when there's high conflict. A lot of courts will direct the parties to only communicate through one of those apps. Those apps, to the communication in those apps too, is very similar to text messaging. Even though those apps are often court ordered to be the means of modes of communication between high conflict parents who are co-parenting, still, judges are not going to look at your phone and read your OFW messages or your talking parenting messages. You'd have to download them and print them out, and a PDF and whatever, and try to get them admitted that way. Okay, but judges don't log into those. They don't have no remote way to view what's going on. That's not how it works. So you have to actually, the same way you would do with text messages. It's very, 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 very similar to that. So that's how you would get those in. The other thing is video recording. Oftentimes, video is made when there's pickup and drop off, when there's sometimes when the parties still live together, when there's the divorce pending and the parties are still living in the house and they want to record the other party, either the exchange between the two parents or the exchange between the other parent and the child, or something similar. And a lot of parties record that because what better opportunity to get some juicy meaty evidence to help you bolster your position or your present your case than to video record as it happens. That too is no, it's not that too. That's subject to authentication rules as well, but it also falls under rules like wiretap rules that each state has. So one of the things the court's going to look at is how is that video obtained. Okay, if the video footage was obtained illegally, you illegally recording an exchange between your spouse and the child, and neither one of them is aware that you're recording them, or you hacked into your spouse's computer or PC or laptop or tablet and you got video that way, or you hacked into their email and you got video that way, that's illegally obtained. So if the other party brings that up and can prove that, chances are you're not going to be able to have that video admitted. But how about pickup and drop off videos? How about when you are exchanging, both of you are exchanging, the kid, and you need to record what's going on? First of all, never mind whether it's actually going to be admitted as evidence. You have to be careful about doing that. And I often warn people about that. I warn them about not just doing it, but mentioning to a court that you have that. Because, it depends on what your intentions are. Your intentions can come off as being very manipulative and very trying to be very, very sneaky in recording video of pick up and drop off, and then trying to use that against the other party. Now, as a coach and strategist, I warn people about it, but I also tell them that if they're going to do it, that bringing it up in court should be done very precariously. No one needs to know that it's been done. I mean, of course, if the other person is obviously is aware of that you're doing it, they may mention it. That's fine. Unless you're in a state where it's illegal to record someone on video, um, that's fine. You can do that. You're well within your right to do that. But using it is something different. Sometimes it's enough to just record someone, just record the other parent, and they, on video. It's sometimes just them being aware that you're recording them is enough to make them act right, clean up their act. But again, that's a whole nother issue than you bringing it into court and trying to get it admitted as evidence. Once it is brought up in court, though, you might subject the other party to discovery requests asking for copies of those recordings so that they can, dispute, prepare, explain, blah, 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 anything that's in the video recording. So that's another thing to be concerned about. But if those recordings are done in secret and you're in a state that doesn't allow, you to record in secret and then admit it in evidence, then, your only use for them is to maybe as leverage or as, whatever. As a strategist, I'm always going to find use for something. I'm always looking for leverage. I'm always looking for opportunities. I'm always doing a SWOT analysis. So I'm always looking for opportunities, and I'm always looking for a threat. SWOT: strengths, weaknesses, opportunities, threats. So for me, anything you tell me you have, I want to know about it. I want to see it. I want to hear it. I want to read it. And then I'm going to try to make use of almost anything and everything you share with me. That's totally different than whether or not it's admissible as evidence. Totally different. Totally. I may want to use it as, in mediation. I may want to use it as some sort of negotiation. I may want to use it as, the opportunity to boost my client's position. The opportunities are endless. The things I can do with it are endless. But that's what I do. Your lawyer's not going to do that. And even if they do, it's going to cost you because it's very tedious work. Very, very tedious work. Extremely tedious. But so effective when you are trying to look for any opportunity to level up in your case or strengthen your position or your defense. So, but anyway, again, the videos recordings need to be authenticated. They need to be relevant. If you want the judge to view video recording, it has to be done legally. It has to be authenticated, and it has to be relevant. It has to be relevant to the issues that are current in your case. Again, the one thing about law is that even though there are rules, there are laws. The whole purpose is that any law can be interpreted to support whatever position you take, right? If it weren't the case, then the law would be black and white, and there would be no need for lawyers, right? But that's what lawyers do. And I had to explain this to someone the other day. It's a matter of perspective, right? The judge can see something. You can have a video recording and you take a position that this happened in the video. It's right on video. It's right on recording. And the other party can say, no, that's not what happened. Even though you're watching the video, this is what happened. And the judge can look at both of them and say, you know what, I see both of your perspectives. There's no right or wrong. I don't think either one of you are lying. I just think that you're seeing this differently. And let me tell you how I see it. And that's it. You know, people think facts are, you know, indisputable, undisputable, whatever the word is. um, they can be, but that doesn't mean that you're right and the other person is wrong, or vice versa. It just means that, you know, facts can be interpreted the way you interpret them. You know, where you stand or where you sit, you can see things entirely different. Right or no right or wrong. That's just how it goes. That's what the law is. That's how it works. But as a strategist, I I look at both. I'm going to look at also, again, with my SWOT analysis, I'm going to look at the complete picture. I'm going to look at it from every angle. I'm going to stand in my adversary's shoes. I'm going to stand in the guardian ad litem's shoes. I'm going to stand in the court's shoes. Everybody who has a play or has a position in this chess game, I'm going to look at everything that you present to me from their perspective, and I'm going to analyze it from their perspective. That's just what I do. So, video recordings taken in open space. Now that's not an issue with respect to illegality, or, you know, however it was obtained, or, you know, expectations of, you know, privacy, whatever. So if you video record your ex or soon to be ex in a public space, in an open space, chances are you don't have to worry about, you know, whether or not it was obtained or proving how it was obtained, etc. You just have to prove, you know, authenticated still, and that it's relevant. Okay. And that's for either side. Both sides are going to argue either way, depending on where they stand. Excuse me. I don't have my water here. So, if you have a ton of text messages, videos, audio, Zoom recordings, the doorbell ring thingy, video from that, baby monitor, audio or video. I mean, there's so much now. Cameras in the house. If you have those kind of recordings, it's best to know. Do it, first of all, as long as it's not illegal. Do it. And then go get someone. If you don't have a lawyer, get someone to help you understand how to organize it, prioritize it, categorize it, so that it can be used to your benefit, whether it's in a courtroom, in a mediation room, in the, you know, on your own for whatever reason. Do it. Okay. It can be so beneficial for you. So anyway, I'm going to open it up to any comments. Okay. I don't see any comments. I will talk about audio and other audio pretty much follows a lot of the video, but I wanted to talk more about audio in another live, because there's so many other things that go along with audio. So anyway, that is it for today. Again, my workshop is going to be a pro se trial prep workshop. It's going to be a 3-part series. It's going to help pro se litigants prepare for trial and to get through trial. And I'm going to, it's taking longer than I thought, actually, because as I'm doing it, I'm realizing there's so many other issues that come up that pro se litigants, and I'm getting a lot of the information from my groups and my other pages where people are asking me questions, and it's prompting me to add. I keep adding, and I need to stop, actually, so that I can get this done. But look for that pretty soon. If you're following me on Facebook or Instagram or YouTube, you'll find that information there. Also, if you're on my email list, I'll keep you updated that way as well. But join here on the lives every Thursday at 4 p.m. live on Facebook, YouTube. That's it. And my groups and on my business page, the Divorce Solutionist. But if you have any questions, comments, concerns, you can always send me a private message on Facebook, or you can email me at divorcecoachesq@gmail.com, or you could just go to my website at www.thedivorcesolutionist.com and hit contact me and fill out the form. Or there's a little chat bot on there that asks you, if you want to talk to me, just say yes, and I'll respond as soon as I can, as long as it's during business hours. So anyway, until next Thursday, thank you.